very learned friends on the dais and off the dais. It's a matter of great fortune for me that I have been asked to say something. I won't say enlighten you, but say something today. And it is a matter of greater good fortune that I am the last speaker of the day, and so you would also all be tired by now and won't be expecting much from me. So, Mr. Mehta, for whom I have profound regard and respect, and is definitely more learned than me, has already expostulated to you about the changes in the Evidence Act. Dr. Seema Singh has also spoken, and they are all much more equipped than me to speak on this. Because the very first thing that I would like to say before anything else is that whenever there is a new legislation, its pluses and minuses are worked out when it is implemented. So it is only, we are right now theorizing. We are theorizing on the basis of what the new provisions say. It is only tomorrow when practically these provisions come up for consideration before courts, and unfortunate people like me will have to grapple with it, and people like Mr. Mehta would raise ingenious arguments this way and that we will really know what these provisions mean, how they work out, and really iron out these provisions. Having said that, there can be absolutely no doubt about the fact that this bill was a necessity. It is extremely surprising that it has taken 75 years for this bill to come. Like Mr. Mehta said, we have been living these 75 years with words like United Kingdom, Her Majesty, and things which have no place after 1950. We are now in 2025. Those provisions were still in the statute. And I really don't know if someone ever tried to enforce those provisions in court, what the court would do. But it is obvious, absolutely obvious, that these things had to be done away with. And so a revamped Evidence Act was an absolute imperative necessity. And it is a matter of credit. I mean, I'm not politicizing it, but it is a matter of credit that at least this government has come to that realization that this had to be done. But what is apart from that is actually only a cosmetic change. I mean, it's just a matter of unfortunate that all these years these remained on the statute. They could have been done away by anyone else. But what is more important, I am not going to speak much on it because you have heard Mr. Mehta at considerable length. But what is more important is that if one sees the general trend of thought behind this Sakshi bill, the idea is to expedite trials. That is clear, absolutely clear. And what Dr. Seema was saying about the fact that sometimes if trials run on, you may end up succeeding in paper, but you end up losing in fact. And that has been to a great extent, the bill has tried to do away with it. How far it works will of course have to be seen in practice, because there are certain very new provisions in this bill which specifically deal with evidence and trial, which have to be tested, but they are welcome provisions. For example, and I am only going to concentrate on one aspect because that is the main aspect of this bill as per the statement of objects and reasons. If you see the statement of objects and reasons of this bill, para 2 says, the existing law does not address the technological advancement undergone in the country during the last few decades. So the basic purpose of this bill and the changes it has made, and the reason why probably the government felt that you can't just amend the act again, but you have to bring in an entirely new act, is because of the rapid technological advancement that we have been undergoing. And as a judge, I can say that in practice, when we are in courts, we are finding grappling day in and day out with challenges which are coming up because of these new technological advancements, especially internet advancements and the availability of information on the internet, the manner in which you can access information. These are things which sometimes even I am actually technologically somewhat challenged, but even the most erudite persons who are net savvy, who are technologically savvy, sometimes when they have to grapple with this on a legal front, it becomes very difficult. And this bill does a lot at the statutory level to try and solve that problem. How it works in practice, as I said, we have to see. Because if you see para 3 of the statements of objects and reasons, it says the proposed legislation, Bharatiya Sakshi Adhiniyam, provides us under, it provides that evidence includes information given technology, etc., electronically. It provides for admissibility. It seeks to expand the scope of secondary evidence. It puts limits on facts which are admissible, etc. So the main raison d'etre of this bill is basically to deal with technological advancements. There are a lot of other changes here and there, but this is the main idea of this bill. And if we go to the provisions in this bill which deal with it, I am just referring to one or two of them. If we see section 2C, which talks about the definition, the definition clause, when it says document includes electronic and digital records. That's all right. Then it says in illustrations, an electronic record on emails, server logs, documents on computers, laptop or smartphone, messages, websites, locational evidence and voicemail messages stored on digital devices are documents. The intention is obvious. Smartphones, voicemails, documents stored on voicemails and smartphones, these are things we have been seeing for the past 15 years. This is not something new. But still all these had to be incorporated, because otherwise we have day in and day out people coming up and saying this is a WhatsApp message, it's got 2 blue ticks. What is the significance of 2 blue ticks? Now for example, till today we do not have a provision by which service by WhatsApp is accepted. Courts are giving orders saying that you can serve by WhatsApp, and we know for a fact that if A sends B a WhatsApp and 2 blue ticks come, there is nothing more credible to show that B has seen that message. There can be no explanation unless he says someone else has accessed my phone and opened my WhatsApp and seen it. But because unlike email, we have incorporated email as a method of service. But email actually there is, unless you ask for a specified, you pay money and ask for an automated response, etc., there is no proof of receipt of email. So when you say I have served someone by email, you don't know whether he has received it. But when you say I have sent him a WhatsApp and I have got 2 blue ticks in response, then I don't see why that should not be treated as conclusive proof of service of that particular message to that person, even more than email. And it is these things, voice messages, electronic locational messages, these are the things which are now being brought into into the Evidence Act. Now when we come to evidence definition, it says statements or any information given electronically, documents including digital records. Now more importantly, if I take you straight to section clause 57, and Mr. Mehta read out of the 4 explanations which came. Those 4 explanations are practically the backbone of this new bill, because they cover everything. Section 57 talks about primary evidence, and it's very important, because explanation 4 says where an electronic or digital record is created or stored and such storage occurs simultaneously or sequentially in multiple files, each file is primary evidence. So if you store an electronic record and store it simultaneously in 5 files, each file becomes primary evidence. Explanation 5 says where an electronic or digital record is produced from proper custody, such electronic and digital record is primary evidence unless disputed. So unless custody is disputed, the record produced from proper custody is primary evidence. Then where a video recording is simultaneously stored in electronic form and transmitted or broadcast or transferred to another, each of the stored recordings is primary evidence. Where an electronic or digital record is stored in multiple storage spaces. Now this is a very interesting provision. Explanation 7. Where an electronic or digital record is stored in multiple storage spaces in a computer resource, each such automated storage, including temporary files, is primary evidence. Now that is an extremely, it shows the intent of this bill, because temporary files, as I understand, I may not be fully correct on it, but what I understand of temporary files is, whenever you create a document, a temporary file is created with it. You may erase the document, the temporary file still remains on your system. And therefore, when they include even temporary files, the idea is that if you go into the system and find this document was created at some point of time, but that document is not there, but its temp file is still available, that temp file is primary evidence. Now that clearly shows the idea is, don't try and escape trials by going into nitty-gritties and hyper-technical details of evidence. If it is anywhere there on your system, God help you. That's the idea. Now it says, and then when we come to secondary evidence, let's see, in secondary evidence, we have included oral admissions, written admissions, evidence of a person who has examined a document, the original of which consists of numerous accounts or other documents which cannot conveniently be examined in court, and who is skilled in the examination of documents. So even in secondary evidence, they have incorporated so many things that once crosses primary and secondary, the scope of evidence has become that large that you can't try and escape a trial. That's why I second what Dr. Seema said, that the idea is, don't try and scuttle trials by going into evidentiality nitty-gritties, saying that this is not primary, this is not secondary, this is not admissible, this is inadmissible. Now here, everything has been covered: electronic, non-electronic, oral admissions, written admissions, even expert evidence by a person who is capable. Now the only other provision on which I would like to just say a few words is section 63, because many of the other provisions my learned friends have already spoken. 63 is the main provision which deals with admissibility of electronic records, and it starts by saying, notwithstanding anything contained in this adhiniyam, so it's a non-obstante clause. It will have precedence over everything else. Any information contained in an electronic record which is printed on paper, stored, recorded or copied in optical or magnetic media or semiconductor memory, produced by a computer or any communication device, etc. If the conditions mentioned in this section are satisfied, it becomes admissible in evidence. Now let's come to the conditions. The conditions say, and the main condition which has been changed is subsection 3. Now subsection 3 earlier, subsection 3 as it stands today says, where over any period the function of creating, storing or processing information for the purposes of any activity regularly carried on over that period, as mentioned in clause 2A, was regularly performed by means of one or more computers or communication device. Now when you come to the definition of communication device, is not defined in the Evidence Act. It says you will go to the definition in the IT Act. IT Act in communication device covers cell phones, personal digital assistants, combination of other devices used to communicate, send or transmit any text, video, audio or image. So any kind of transmission now gets covered. And it says communication device, whether A in standalone mode, B on a computer system, C on a computer network, D on a computer resource enabling information creation or providing information, or, now this is very important, or E through an intermediary. Now even information received, electronic information which is stored through an intermediary, has got incorporated into admissible electronic evidence. Now when you come to intermediary, again intermediary is not defined in the Evidence Act, but the Evidence Act says that which are expressions which are not defined, you go to the IT Act. Now IT Act, when you go to intermediary, now intermediaries is now a big issue of debate, because you have the intermediary guidelines. To what extent the intermediary guidelines are binding, etc., that's subject matter of challenge, but that's a different aspect. But if you go to intermediary, it says intermediary with respect to any particular electronic records means any person who on behalf of another person receives, stores or transmits that record or provides any service with respect to that record, and includes telecom service providers, network service providers, internet service providers, web hosting service providers, search engines. So even if it is something through Google, search engines, online payment sites, online auction sites, online marketplaces, cyber cafes. Now today, in some cases even before me, it is sought to be argued that a particular organization is not an intermediary. That's a different aspect, but otherwise intermediaries covers all these things. And so even if it is electronic information which is received through an intermediary and it is stored through an intermediary, that also becomes admissible electronic evidence under this particular clause. So the idea, which at the end of the day what I wanted to say was that the idea behind this bill, which I think is extremely laudable, is that there should be no loopholes left. Evidentiary loopholes are the bane of our trial system, whether it is criminal trial or civil trial. Matters continue for years after year on the basis of evidentiary loopholes. Someone says this is not admissible in evidence, that is not admissible in evidence, and on that basis appeals are filed, trials are stayed. Now the intent of this legislation is perfectly clear. The intent is to see that these kind of attempts do not work, and that it becomes a watertight evidentiary system which we have. As I said, the bill has done everything possible that I think could have been done towards that end. No doubt if it is put to debate in Parliament and it is examined, there may be changes. Nothing is perfect. And it's not for me right now to start. Either it would not be seeming of me either as a judge or as otherwise when the matter is before the parliamentary subcommittee to make any comment on that. But definitely the bill has a laudable purpose to serve. It was necessary it was definitely necessary, and I for one would hope that this bill goes through, and most of these provisions I find seem to be correctly drawn. There may be, as I said, some pluses minuses here and there, but the intent of the statute is to see that trials are not done, that cases proceed as fast as possible, and which is something which is an avowed something which has to be desired in every judicial system. So at the end of the day, as I said, I personally feel that many of the bill has tried to sort of block many of the loopholes which were there in the earlier evidence system, and I think that of course if it is subjected, ultimately it has to be, if it goes through Parliament and in the manner in which it finally comes out as an act, it is only when we implement it in courts and when it is subjected to judicial scrutiny that there may be some creases which have to be ironed out. But as a statutory document, I think it is a well made out document, and it does deserve acceptance. Prima facie, that's what I feel. In fact, I was seeing just one of the provisions which of course this is more like an aside and a kind of concluding sort of dessert. One of the provisions I find is which I find in clause 122, which is something which persons who are dealing with rent control would be very familiar with. It says, no tenant of immovable property or person claiming through such tenant shall during the continuance of the tenancy or any time thereafter be permitted to deny that the landlord had a title to such immovable property. So the earlier provision did not have the words or any time thereafter. So now the legislature has introduced this to say that it's not just that during the continuance of the tenancy you cannot dispute the title of the landlord, even thereafter you cannot dispute it. Again, that shows the intent of the provision, and so I think it's a well-conceived piece of legislation. The rest has to be left to Parliament and for persons like me to tear it apart in courts with the assistance of Mr. Mehta and other learned counsel. Thank you.